Welcome everybody to the Banco Court tonight. It's my pleasure to introduce Chief Justice Kiefel to deliver the inaugural Lord Atkin Lecture. And in doing that, I'll undertake a quick review of Her Honour's career. She attended school at Sandgate High. Now, you might think that's a little too early in her career to be worth mentioning, but there is a small link with the Atkin family. As you're probably aware, Lord Atkin was born in Brisbane 150 years ago today. His father, Robert Atkin, had tuberculosis, and the family spent a good deal of time at Sandgate for him to receive the reviving sea airs. He was very fond of Sandgate and he was buried there. There's a monument over his grave not far from Her Honour's High School, which was restored in 1937 with funds from Lord Atkin. 80 years on, it's sadly in need of work again, and there is a fund to which donations may be made. But returning to Chief Justice Kiefel, she was admitted to the Queensland Bar in 1975. She had a broad practice, but like Lord Atkin, was a leading commercial barrister. There's another small connection to be found here. The Atkin family, while in Brisbane in the mid-19th century, became close friends with the Douglas family, the forebears of so many of our barristers and judges. Her Honour was in chambers in the Inns of Court with Bob Douglas as a barrister, and of course remains a friend of Justice James Douglas of this court. While a barrister, Chief Justice Kiefel took a sabbatical to undertake a master's at Cambridge. Lord Atkin, on the other hand, had studied at Oxford. There's another difference here. Chief Justice Kiefel emerged from her Cambridge degree with prizes. Lord Atkin's academic record was relatively disappointing. But both, later in their careers, when they'd become judicial luminaries, were appointed honorary fellows of their respective colleges. In Chief Justice Kiefel's case, Wolfson College; in Lord Atkin's, Magdalen. Like Lord Atkin, Her Honour took silk relatively early in her 30s, and like him, didn't spend long in that role, 6 years in her case, 7 in his, before being appointed to the bench. And again, like Lord Atkin, Her Honour progressed through a series of judicial appointments. Lord Atkin was initially appointed to the King's Bench Division, then to the Court of Appeal, ending his career on the House of Lords and Privy Council. Chief Justice Kiefel was appointed to the Supreme Court, then the Federal Court, and then the High Court. And here's another connection. Since her appointment to the Federal Court in 1994, Chief Justice Kiefel has had chambers in the Commonwealth Law Courts building in Tank Street, on the very site where Lord Atkin was born in 1867. She spent rather longer on the property than he did. He left at 3 years of age. One of Lord Atkin's daughters said that as a boy he had an ambition to be Lord Chief Justice of England. That was never achieved, but Her Honour, of course, reached the pinnacle of the Australian judicial system with her appointment this year as the 13th Chief Justice of Australia. The very first Chief Justice, Sir Samuel Griffith, like her, was of course a Queenslander, but unlike her, had a previous career as a politician. He stepped into Robert Atkin's seat with the latter's endorsement when Atkin became too ill to continue. And they remained friends, as did later Griffith and Lord Atkin himself. As a judge, Lord Atkin is said to have been courteous and incisive in his questioning, a description of judicial style which could very readily be transposed to Her Honour. As a member of the Privy Council, Lord Atkin, like Chief Justice Kiefel, ruled on a number of occasions on questions of Australian constitutional law, although Section 44 does not seem to have come to His Honour's attention. More importantly, he left a lasting impact on the common law, and there's every reason to think that the Chief Justice will also leave a significant legacy in shaping Australia's common law. But of course, Lord Atkin is also famous for his spectacular dissenting judgment in Liversidge and Anderson. I would not rush to predict spectacular dissents by the Chief Justice, although I wouldn't rule anything out. But this, of course, brings me to the subject on which Her Honour is going to speak tonight. So without further ado, I'll invite Chief Justice Kiefel to the lectern.
Thank you, Chief Justice, for those kind words and some remarkable observations of similarity and dissimilarity. Judicial colleagues, members of the legal profession and of the Academy, ladies and gentlemen. Yes, my talk tonight is entitled Judicial Courage and the Decorum of Dissent. Lord Atkin's biographer observes that the case of Liversidge and Anderson was decided by the House of Lords in late 1941, when the Second World War was at a low point for England. Germany had taken the Balkans and Crete and had invaded Russia. The Japanese army was menacing Singapore and the Malayan Peninsula. The United States had not yet joined the Allied forces. It is times such as these that extraordinary powers are given to government officials. The power in question in Liversidge and Anderson was Regulation 18B of the Defence General Regulations 1939, by which a person could be detained in prison if the Home Secretary had reasonable cause to believe the person to be of hostile origin or associations. It was made under legislation the purpose of which was public safety and the defence of the realm. Robert Liversidge was an alias used by Mr. Jack Perlzweig, a British citizen born to Russian Jewish parents. He was described as a somewhat shadowy and mysterious character who had become a wealthy businessman by the late 1930s. In May 1940, while serving as a volunteer pilot officer in the Royal Air Force, he was detained in Brixton Prison under Regulation 18B, and he claimed that his detention was unlawful. The Home Secretary, Sir John Anderson, defended the claim by asserting that he believed Mr. Liversidge to be a person of hostile associations. Mr. Liversidge sought particulars of the grounds on which the Home Secretary had reasonable cause for that belief. The courts below refused to order the Home Secretary to provide those particulars. Mr. Liversidge appealed to the House of Lords. There was no issue about the validity of the regulation. Lord Atkin himself did not doubt that delegated legislation made under the Emergency Powers Defence Act of 1939 was capable of conferring unlimited power on the executive government in time of war. The question was whether Regulation 18B did so. The answer to the question lay in the words, "has reasonable cause to believe." The Home Secretary's argument in the House of Lords was that his decision could not be called into question in a court of law. So long as he swore that he had reasonable grounds for his subjective belief, it could not be challenged. Mr. Liversidge's case was that the words "has reasonable cause" require an objective assessment of whether there exist reasonable grounds for the Home Secretary's belief. All of the members of the House of Lords hearing the case, save for Lord Atkin, held that the Home Secretary's opinion was unchallengeable and that he was only required to act in good faith. The senior law lord was Viscount Maugham, the elder brother of the novelist Somerset Maugham. He reasoned that the discretion given could not possibly be subjected to the criticisms and control of a judge in a court of law. Lord Roma took a similar approach. Lords Macmillan and Wright considered that the standard of reasonableness was a personal standard to be set by the Secretary himself. Lord Macmillan's speech emphasised the wartime nature of the regulations. He said that, quote, "When the life of the whole nation is at stake, it might be given a meaning which the courts would be slow to attribute to it in peacetime." Lord Atkin accepted that in time of war a judge might not favour the liberty of the subject. Nevertheless, in his view, a judge could not go beyond the natural meaning of the words, which remained unchanged. He said, quote, "I view with apprehension the attitude of judges who, on a mere question of construction, when face to face with claims involving the liberty of the subject, show themselves more executive-minded than the executive. In this country, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty for which on recent authority we are fighting, that the judges are no respecters of persons who stand between the subject and any attempted encroachments on his liberty by the executive, alert to see that any coercive action is justified in law. In this case, I have listened to arguments which might have been addressed acceptably to the Court of King's Bench in the time of Charles I. Lord Atkin's dissent has been described as one of the most significant constitutional speeches from the House of Lords in the last 100 years or so, and the most famous and celebrated dissent in United Kingdom jurisprudence. Eminent jurists such as Lord Bingham have been more than generous in their praise of it. Lord Bingham said that, even in that extreme national emergency, there was one voice, eloquent and courageous, which asserted nobler, more enduring values. Lord Atkin's view about the meaning of the regulation may have been consistent with earlier authority, which held that reasonable cause requires more than mere belief. There had to be a basis in fact for the belief. However, academic opinion about the decision in Liversidge and Anderson was, at the time, divided. Sir William Holdsworth and Professor Goodhart, for example, supported the majority view. Whatever views were held about its correctness, many commentators thought Lord Atkin had gone too far in his use of extravagant language. The editor of the Law Journal at the time said that it is difficult to answer the cogent reasoning of the dissentient law lord, but added that it is a pity that Lord Atkin saw fit to add to his forcible judgment matters which were not necessary to his reasoning, and therefore added nothing to its strength. Justice Applegarth, in a speech about Lord Atkin, in an article about Lord Atkin, put it more directly. He said that it was unfortunate that Lord Atkin took, quote, an unnecessary swipe at his colleagues. Justice Applegarth and the editor of the Law Journal were not referring to the passage I have just quoted. They were referring to Lord Atkin's borrowing from Alice in Wonderland to describe his colleague's reasoning. Lord Atkin said, quote, "I know of only one authority which might justify the suggested method of construction. When I use a word," Humpty Dumpty said in rather a scornful tone, "it means just what I choose it to mean, neither more nor less. The question is," said Alice, "whether you can make words mean so many different things." "The question is," said Humpty Dumpty, "which is to be master, that's all." And then he said, "After all this long discussion, the question is whether the words, quote, 'if a man has,' can mean, quote, 'if a man thinks he has.' I am of the opinion that they cannot, and that the case should be decided accordingly." Lord Simon, the Lord Chancellor, had not sat on the case, but came to hear about the Humpty Dumpty reference and sought to persuade Lord Atkin to join in with the majority, or at least to tone down his dissenting opinion. It might seem strange to some that a judge who disagrees with the majority opinion might nevertheless join with them. But it was then a well-established tradition that judges refrained from dissenting unless a case was of particular importance. Lord Radcliffe said that when he joined the House of Lords in 1949, a dissent was a very serious thing. The justification for the practice appears to have been that the exposure of differences of opinion might detract from the authority of the House of Lords. Lord Simon was sufficiently concerned about the matter that he wrote to Lord Atkin, asking him whether he really thought that the very amusing citation from Lewis Carroll was necessary. He said, "I fear that it may be regarded as you wounding to your colleagues who take the view you satirise, and I feel sure you would not willingly seek to hold them up to ridicule." Lord Atkin's biographer thought that Lord Simon might be criticised for attempting to edit Atkin's speech. For my part, I consider it perfectly proper for a senior judge to seek to persuade another judge to remove references of this kind. Lord Simon himself explained to Lord Atkin that he was principally concerned about the dignity of the court. The likely effect on the feelings of Lord Atkin's colleagues was no doubt another means by which he sought to persuade him. Lord Atkin was not persuaded. In his reply to Lord Simon, he said that if he had not had the highest esteem for his colleagues, he would have used very different language to what he had used. One can only speculate as to what literary texts might have been employed if he had not regarded his colleagues well. He said he did not think he was ridiculing them, but rather the method which they had employed in construing the regulation. He concluded in his note in reply, "I consider that I have destroyed the majority view on every legal ground, and it seems to me fair to conclude with a dose of ridicule." He would not alter the opinion. Lord Simon tried once more and pressed Lord Atkin to omit the jibe, but it was to no avail. The response of the other members of the House of Lords after publication of the dissent was to refuse to speak to Lord Atkin or to lunch with him, this is very serious, for a considerable time. In English parlance, he was sent to Coventry. It is difficult to find examples of speeches in the House or later in judgments of the Supreme Court which approximate the disdain in the tone of Lord Atkin's dissent. This may in large part be due to the fact that it was not then, and is not now, considered to be good form to be discourteous in a judgment about the reasoning of other members of the court. It is not generally considered necessary to expressing disagreement or to refuting another's argument. Generally speaking, judges in England and in Australia maintain courteous relations towards one another. Of course, there have been exceptions. Lord Reid's dissent in Shaw and Director of Public Prosecutions has been described as one of the more vigorous dissents in the House of Lords. The question before the House was whether conspiracy to corrupt public morals was a common law misdemeanour. The majority held that it was, and that the courts had a residual power to superintend those offences which are prejudicial to the public welfare. Lord Reid did not approve of the courts being guardians of public morals. He said that, quote, "where Parliament fears to tread, it is not for the courts to rush in." The consequence of holding that such an offence exists, he said, is that this branch of the law will have lost all the certainty which we rightly prize in our other branches of the law. By comparison with Lord Atkin's dissent, this is but a gentle rebuke. Perhaps closer to the mark is Lord Bridges' speech in the Spycatcher case in 1987. The question was whether injunctions against newspapers publishing allegations from the book should be continued given that the book had been published in the United States and the UK government had announced that it would not prevent importation of it. And of course, the book involved matters of some suggested secrecy involving MI5. The majority nevertheless continued the injunction. Lord Bridge, however, said that it was nonsensical to speak of preventing disclosure once information is freely available to the public. His conclusion was even stronger. He said, "I have had confidence in the capacity of the common law to safeguard the fundamental freedoms essential to a free society, including the right to freedom of speech. My confidence is seriously undermined by your Lordship's decision. Freedom of speech is always the first casualty under a totalitarian regime." One can almost hear his colleagues' sharp intake of breath as they read this for the first time. It has been suggested that impassioned dissents are not the norm in the High Court of Australia because the court's steady constitutional diet, being largely limited to the generally drier questions of the distribution and separation of powers in a federal polity, seems not to ignite much in the way of passionate prose. This did not prevent Justices Gavin Duffy and Rich from suggesting that a construction of the defence power that extended to fixing the price of bread during war would paralyse the states during wartime. Invoking Aesop's fables, they said, "The defence of the states would be the defence which King Stork extended to the frogs who invoked his assistance." The term Great Dissenter is said to have been first used to refer to Justice Harlan of the US Supreme Court. Sir Isaac Isaacs was the first to be called a Great Dissenter of our High Court, but as we know, he was not the last. Even if one were to take the view that literary allusions and extravagant language should not be employed in judgments, an exception could surely be made for one in which Justice Isaacs dissented. The appellant was a woman who brought an action against another woman for the loss of her husband's affections. The majority held that whilst such an action was clearly available to a husband, it was not to a wife. They reasoned that the common law has always recognised the dominion exercised by the husband over the wife, and that the husband's action is based upon an interference with that dominion. A wife, on the other hand, never had such a power. Justice Isaacs, after quoting some passages from The Taming of the Shrew, said, quote, "There is no need of antiquated reasons springing from a primitive state of civilization originally impressed into service to attain justice, later abandoned in favour of better reasons, and today utterly repugnant to the present conditions of society. Still less is there any justification for rummaging around the ruined and abandoned structures of the past to find materials for erecting a barrier against the wife's claim for redress when a clearly recognised principle of law admits it." In an article about the case in a woman's magazine, a person who described herself as a woman's solicitor observed that all the judges except Sir Isaac Isaacs declared that sauce for the gander was not in this instance suitable as sauce for the goose. In more modern times, it is of course to the late Justice Scalia that one turns for outstanding examples of a no-holds-barred approach to dissent and the use of flamboyant language. He referred to the majority's interpretation of the Obamacare legislation as pure applesauce and interpretive jiggery-pokery, involving somersaults of statutory interpretation. Perhaps he too, like Lord Atkin, thought that this was not a personal attack, but he was simply mocking their methods. There may, of course, be other motivations. In another dissent, he took aim at his colleague's judgment, which had begun with a rather dramatic flourish about the Constitution promising liberty. He said if he had joined in such a judgment, he would hide my head in a bag, and that it showed that the Supreme Court had descended from disciplined reasoning to the mystical aphorisms of the fortune cookie. How refreshingly unremarkable are most dissents by comparison. In the past, but less so now, a feature of a polite dissent was that they were expressed at the outset with regret and humility. Whether the words were always sincere is perhaps another question, but that's not to the point. Lord Reid's dissent in Shaw and Director of Public Prosecutions began with an expression of regret that he was in fundamental disagreement with the majority. Justice Isaacs often prefaced his dissenting opinions with remarks such as, "I have the misfortune to differ from my learned brethren," or "I regret that I cannot come to the same conclusion." In another case, he added that he was fully conscious of the weight of judicial opinion opposed to my own, all of which I unfeignedly respect and value. Justice Ninian Stephen, who recently died, was a most courteous judge, even in dissent. On occasions, he would express regret at having the misfortune to disagree with other members of the court. In other cases, he would merely commence his judgment in very simple terms, such as, "In my view, the doctrine of restraint of trade is not applicable on the facts of this case," and proceed to explain his reasons. So stated, no expression of regret is necessary. This aligns most closely with contemporary practice. Like Lord Atkin's dissent in Liversidge and Anderson, Sir Ninian Stephen's dissent in Henry and Boehm was later vindicated. Unlike Lord Atkin's, the dissent has been said to exhibit no histrionics, no passionate appeal to the intelligence of a future day, and no bitter regrets at being unable to agree. Words such as courageous are often employed to describe a lone dissent or the judge who wrote it, perhaps by way of acknowledging that it may sometimes be difficult to stand apart from other members of the court or to express an unpopular view, one contrary to strong public opinion, which Lord Atkins in Liversidge and Anderson may well have been. It may be accepted that a dissent is an act of independence. It shows a strength of will which may, or may not, be commendable. But surely these are qualities which we expect of judges, particularly those sitting on our highest courts. Judges make unpopular decisions. They would not become judges if being popular was important to them. Can a dissent realistically be considered as an act of courage? Some distinguished judges have doubted that it can. Lord Radcliffe observed that no one tried to send Lord Atkin to prison for dissenting from the majority in Liversidge and Anderson. He considered epithets such as heroism and gallantry to be comically inappropriate to judgments. The time has not come in this country, he said, when a judge has to summon up any reserves of heroic quality in order to express a novel opinion on a constitutional matter or one possibly unwelcome to the executive of the day. Former Chief Justice Murray Gleeson of the High Court is of like mind. He suggests that only someone given to mock heroics or lacking a sense of the ridiculous could characterise differences of judicial opinion in terms of bravery. He said that there may be occasions when a judge needs to show moral or even physical courage, but by and large, judges operate in an environment which is uniquely secure and which rarely tests their resources of heroism, no matter how exciting it may be to think otherwise. It should also be observed that it is not always the dissentient who makes the unpopular decision. Chief Justice Latham's dissent in the Communist Party case may have been described as lone, vehement and incredulous, but it was the majority of the High Court who, at the height of the Cold War, held invalid legislation which purported to declare the Communist Party to be an unlawful association, and empowered the Governor-General to declare further bodies to be unlawful associations. There is also an aspect of dissent, a dissent which involves an attack upon fellow judges, which may tell against courage. It may be expected that there will be no response to the attack. It would be a rare occasion for those in the majority to join in the fray. There is, after all, no reason to convince the reader of the view which prevails. More importantly, it would not promote a good image of the court as an institution. There may be more than one motivating force behind a dissent which uses overblown language and literary references and is harsh in its criticism of the other judges. In some cases, it may be that the author considers it necessary to be provocative, so that the dissent is not overlooked in the future, when other like-minded judges will correct the error of the majority. Our High Court has accepted that, quote, a dissenting judge will often see his or her judgment as an appeal to the brooding spirit of the law, waiting for judges in future cases to discover its wisdom. Yet one can see from the example of Sir Ninian Stephen in Henry and Boehme that an appeal of this kind is possible without being impolite. Some dissents may provide entertainment. I trust that you have been this evening. We may all be amused from time to time by a witty dissent, at least when they are not directed at us. Law students pore over them, though their time may be better served analysing the more mundane majority opinion. Legal commentators like to quote them. There are even collections of them published under titles such as Great Australian Dissents. On the other hand, some may consider that a judge's surrender to a desire to entertain the reader or to seek popularity is somewhat self-indulgent, given the serious nature of the task which judges undertake when deciding a case. It is possible that the losing party might feel a moment's exhilaration at the attack on the majority, but then again he or she might also feel that his or her case is belittled by the humour. As for Lord Atkin's motivations, some of the language employed might suggest that he wished to be seen to speak with moral authority. Yet, as I have earlier mentioned, in conversations with one of his daughters, it would seem that he did not doubt that in wartime a judge should not lean towards the liberty of the subject. It must be understood that by this time Lord Atkin was almost 74 years of age and had been a judge for 28 years. A measure of annoyance can be detected in his dissent. But what is most clearly conveyed is the high level of confidence in the correctness of his view. This is a common feature of dissents of the kind I have been discussing this evening. By contrast, Sir Ninian Stephen is said not to have subscribed to the view that every legal question admits of only one right answer. It would seem then that acceptance of the possibility that one might be wrong may serve as an encouragement to humility. Lord Atkin was clearly aware of the likely response from his colleagues. The day before he was due to give his dissenting speech, he said to one of his daughters that he hoped that they would be speaking to him afterwards. No one has suggested that he was ill-mannered or impolite to his colleagues in general, which suggests that he weighed the effect of his speech upon his colleagues against the impact it would have more widely. It is important that the relations between judges be courteous, and generally speaking, they are. It is especially important for final appellate courts, which comprise a small number of judges who work closely together. The work of these courts requires a level of collegiality for the efficient discharge of their work. But in the end, it is the court as an institution which matters most, not the hurt feelings of judges. A judgment which ridicules other members of the court cannot but detract from the authority of the court and the esteem in which it is held. A humorous dissent may provide the author with fleeting popularity, but it may harm the image the public has of the court and of its judges. You will recall that Lord Wright was one of the majority in Liversidge and Anderson, and so one of the targets of Lord Atkin's jibe. Yet his obituary of Lord Atkin has correctly been described as forgiving. He referred to Lord Atkin's judgment in Liversidge and Anderson as showing his habitual courage and independence. But he concluded the obituary by saying that the value of Lord Atkin's work will not be found to lie in particular judgments, valuable and important as they are, but in the animating motive force which inspired him. Thank you.
Well, can I thank the Chief Justice for not lighting on any local examples, which may just reflect the fact that we're all very mild-mannered here. That was a fascinating traverse of the topic, and I'm sure we're all very grateful for it. It had those anecdotal touches, but it's a serious and considered overview of the question of how one expresses an independent view without damaging the respect in which the court is held as a whole. Can I thank Chief Justice Kiefel again, and can you show your appreciation? Now, Justice Applegarth is the driving force behind the exhibition and the lecture tonight, so I'll invite him to speak to you about it.
Chief Justice Kiefel, Chief Justice Holmes, judicial colleagues, ladies and gentlemen. 150 years ago, at nearby Tank Street, on the 28th of November 1867, Richard James Atkin was born. Tank Street, as the name suggests, was the site of a very large water tank. Vic Atkin's mother was Welsh. His father was Irish. Just before Christmas 1867, Robert Atkin wrote to his parents-in-law in Wales about the heat of Queensland at Christmas and about their grandson. He wrote, "I'm never tired of admiring your grandson, who is, if the womenfolk are to be believed, an infant combination of Hercules and Apollo." Dr. Kevin O'Doherty had attended the birth of Dick Atkin in 1848. O'Doherty's medical studies in Dublin had been interrupted when he was charged over disloyal publications he was responsible for. He received a 10-year sentence and was transported to Tasmania. Eventually, he came to Queensland as a highly regarded doctor. Robert Atkin's 1867 Christmas letter to his in-laws reported, "Mary had a very delightful doctor. He was exiled for the part he took in Smith O'Brien's rebellion, and although opposed to him in politics, we are very good friends." Robert Atkin and Kevin O'Doherty may have had their differences over Irish independence, but as public figures and unpaid members of Parliament, these friends had a shared vision for the future of Queensland. They and other reformers like Charles Lilly opposed the vested interests of the squattocracy. Robert Atkin argued for fairness towards people in the north of Queensland, for new railways and for new industries of cotton and sugar. Atkin described the Polynesian Labourers Act as a legalised system of kidnapping. He and his colleagues did not want Queensland to become a plantation state built on slavery like the deep south of the United States had been built. Robert Atkin's career as a campaigning journalist and newspaper editor and as a Member of Parliament was short. By late 1871, his health was in terminal decline and his sons had travelled to Wales. He wrote beautiful letters to his son Dick, including one on Dick's 4th birthday, which instructed Dick to always be good and kind, and advised, "If you are always truthful and honourable, you'll find the advantage of it as you grow older." Robert Atkin died at Sandgate in May 1872, aged only 30. Citizens from all sides of politics mourned his passing. One of them, as has been mentioned, was a young lawyer called Samuel Griffith. Atkin only resigned from the Queensland Parliament in March 1872 after he was assured that Griffith would stand for his seat. Griffith was elected to replace Atkin. The rest is history, and you'll see a portrait of Sir Samuel Griffith as you leave this court tonight. One of the letters reproduced in the exhibition is from Mary Atkin, telling Dick and Walter Atkin how their father had passed to heaven and how she would return to Wales to see them soon. The letter ends, "Perhaps someday when you are big men, we will come out to Brisbane and you shall finish the work that Papa only had time to begin." Dick Atkin never travelled to Queensland, but the product of his work as a master craftsman of law and language did. His decisions still guide the law of this country and the rest of the common law world. It's fitting, therefore, that there should be an exhibition about him. And also, it's important that parts of the exhibition be available online throughout the common law world. May I thank the chair of the Library Committee, Justice Fraser, the committee of the library, and especially Mr John McKenna of Queen's Counsel for their support for the exhibition. The library staff have been very dedicated. I can't mention each by name, but may I acknowledge the Supreme Court Librarian, David Bratchford, Catherine Graff, Katie Dean, Kirsten Murray, Linda Phillips, Samantha Faulkner and Charlotte Streeland. Our working group received great assistance from the Federal Court Librarian, Ms Joanna Fear. Joanna is also the custodian of the Atkin portrait, which is with us tonight courtesy of Chief Justice Alsop and our colleagues on the Federal Court. The exhibition which opens tonight explores the influences which made Lord Atkin a great jurist. The section, A Life in Queensland, describes the Queensland into which Dick Atkin was born. It records some of the impressions the Atkins had about their new home. The invaluable contribution of historians Helen Gregory, Dr Ross Johnson and Paul Sayer are reflected in the content of all of the parts of the exhibition. Their research and writing features most, however, in the section A Life in Queensland and in the Robert Atkin section. The exhibition features the influential women in Lord Atkin's life, the mother and the grandmother who raised him in Wales, and his wife Lizzie Hemet. As a newly admitted barrister in London, Dick Atkin was invited to the home of Mr William Hemet in Kent. Hemet had been a fellow MP of Robert Atkin here in Queensland and had nursed him, in Lord Atkin's words, with unremitting care through the last stages of Robert Atkin's life. When Dick Atkin visited the Hemet mansion in Kent, he met two people who were to change his life. One was a local solicitor who promised Atkin his first brief and delivered on the promise, and then gave him enough work to survive at the bar. The solicitor was Norman Herbert Smith. Today, the global firm Herbert Smith Freehills bears his name. Hopefully, the image of Lord Atkin's fee book from those lean early years at the bar will inspire junior barristers when they're in the Supreme Court Library to persist as he did. And I hope it also inspires briefing solicitors to give newly admitted barristers similar opportunities to prove their brilliance. The other introduction made at the Hemet Mansion, named Bulimba, interesting that there's an Aboriginal word as the name of a home in Kent, was to Lizzie, who had been born 12 days before Dick Atkin here at North Quay. They married after a 5-year engagement, and the photograph of their wedding takes pride of place in the exhibition. Lizzie Hemet, later Lord Atkin, was a formidable woman. 100 years ago, in late 1917, her life was darkened when her eldest son and her brother were killed on the same day in the same battle. That darkened her life. Many of the images in the exhibition come to us courtesy of members of the Atkin family. I mentioned in particular Mrs. Elizabeth Barry, Mrs. Sarah Eckersley, Mrs. Rachel Gibbs and Mr. William Atkin. We also sincerely thank Gray's Inn for their assistance in providing digital images. The exhibition aims to capture in a few words and images the Queensland into which Dick Atkin was born and the people who influenced his life. It also aims to educate people about his legacy. Some may think when you travel around level 12 in the library tonight that we negligently overlooked the snail in the bottle case, Donahue and Stevenson. It has pride of place on the ground floor, and I'd encourage you to visit it as well tonight. It's a source of education for the thousands of law students who visit this building every year and the general public about the rule of law, including Lord Atkin's brilliant achievement in distilling the neighbour principle in negligence law. The exhibition isn't a static thing. To complement the Donahue and Stevenson section, the library has created YouTube videos which were kindly produced at the University of Queensland Law School. Those YouTube videos feature 3 of our finest taught scholars, Professor Mark Lunny from the University of New England, Professor Kit Barker from the University of Queensland, and Dr. Kylie Burns from Griffith University. Lord Atkin championed the education of law in universities, the improvement of practical legal education and the rejuvenation of Gray's Inn. The contribution to the exhibitions by our academic colleagues will allow law students and lawyers to better understand the law which Lord Atkin made. Their short video lessons will be available throughout the common law world, from Brisbane to Papua New Guinea to Burma to Birmingham. Justice Keen's video explains why we celebrate Lord Atkin. He describes Lord Atkin's famous judgment in Liversidge and Anderson as a ringing blow for liberty and equality under the rule of law and for the integrity of the English language itself. The part of the exhibition about Liversidge and Anderson is the result of the scholarship and toil of Dr. Karen Schultz from Griffith University. I thank Dr. Schultz, who, like other contributors, had to compress thousands of words of scholarship into the few hundred words which made it onto the walls of the exhibition. We hope that in the coming months additional parts of their work will be included in the online part of the exhibition. When he wrote his famous judgment in Liversidge and Anderson, Lord Atkin was a widower in his early 70s whose home in Wales also became home to grandchildren. As he wrote his famous judgment in Liversidge and Anderson in his study, young children were running around his home, and one of his daughters was running a school teaching children who, like some of his grandchildren, had been forced to leave London during the Blitz. You'll see in the exhibition a photo of 3 little girls at a fair in Wales during the war. They are 3 of Lord Atkin's many grandchildren. Their oral histories about their famous grandfather have recently been recorded by the library and will be released as part of the exhibition in the new year. And it's interesting what you pick up when you speak to people. These little girls and their mother, who'd been an actress, their favourite book was Alice in Wonderland, and they performed plays based on Alice in Wonderland. So I think we may understand where Alice in Wonderland came from. But I digress. At the exhibition entry, you'll see a photo of Lord Atkin on a pier at Aberdyfi in Wales. His granddaughter, Mrs. Elizabeth Barry, recalls in her oral history, "We went down to the jetty because they were about to demolish it as the war started, and they thought they were all going to be invaded. He went down and said, 'No, stop that.'" It was a very typical photograph of him because he liked to wear his old suits. It was a place where he could relax. She also said, he was very good with people. The people in Abu Dhabi really loved him, and his study was open all the time to anybody who wanted to come and get advice. So, as a child, Lord Atkin had been told by his dying father to be good and kind, truthful and honourable. He certainly fulfilled his father's wishes. Late in his life, Lord Atkin wrote, "My father must have been a man of exceptional gifts." And he pointed to the words inscribed on a monument at Sandgate dedicated to his father. Those words state that Robert Atkin was, quote, devoted to the promotion of a patriotic union among his countrymen, irrespective of class or creed, combined with loyal allegiance to the land of their adoption. And a model of the monument has been created by the staff and students of the Sandgate State High School and is on display as part of the exhibition. Lord Atkin was never a rich man. After all, he had 6 daughters to educate, twice as many daughters as the perennially poor Welsh barrister in the Rumpole series. In 1937, Lord Atkin personally funded the restoration of the monument at Sandgate after it had fallen into disrepair. When I first saw it 2 years ago, the monument was in a terrible state of disrepair. In the last year or so, a group of citizens led by Ms Pam Verney, who's here tonight, and others at Sandgate have been jumping through the heritage and bureaucratic hoops and trying to raise funds to restore the monument. In the last few weeks, work has begun in earnest. Engineers, arborists and stonemasons have to be paid. I hope you contribute to the cause, which has gained charitable status from the ATO. There are fact sheets available tonight about the monument restoration project. And it's really hard to imagine anything which would give Lord Atkin and his family greater pleasure than to restore the monument which he restored 80 years ago, a monument which inspired him throughout his life. I'll conclude on this point. In 1933, Justice Evatt of the High Court of Australia wrote to Lord Atkin congratulating him on his judgment in Donoghue and Stevenson. Evatt wrote of Atkin's achievement, "The common law is again shown capable of meeting modern conditions of industrialisation and of striking through forms of legal separateness to reality." 10 years later, in 1943, long before D-Day, the Allies began to think about how to punish war criminals. As Australia's External Affairs Minister, Dr Evatt asked Australia's High Commissioner in London to approach Lord Atkin to be Australia's representative on the War Crimes Commission. Evatt's telegram, which you can see in the exhibition, concluded, "As you know, Atkin is Australian-born and is an outstanding jurist." In the final year of his life, Lord Atkin served as Australia's representative on the War Crimes Commission. He publicly championed the idea that there were crimes which transcended all domestic laws and were, to use the words of a letter he wrote to the Times on 30 December 1943, offences against the conscience of civilised humanity. He thought that this might require ad hoc international tribunals to be constituted. Lord Atkin was an outstanding jurist. We are fortunate that another outstanding jurist has agreed to open the exhibition on Lord Atkin's birthday and so close to his birthplace. We are delighted, as are Lord Atkin's descendants, that the exhibition is to be opened by the Chief Justice of Australia, the successor in title to the judicial office held by Robert Atkin's friend, Samuel Griffith. I invite Chief Justice Kiefel to open the exhibition, Lord Atkin from Queensland to the House of Lords.
Thank you, Justice Applegarth. It gives me great pleasure to officially open the exhibition, Lord Atkin from Queensland to the House of Lords, and I wish the exhibition every success.
And can I invite you to level 12 to see the exhibition and to take part in some refreshments. And that concludes this part of the evening. Thank you.